We thank you very much for being here today. I'm joined today by one of our firm's newest attorneys, Trey Kamick. Trey is a 2013 graduate of St. Mary's University School of Law and is board certified in labor and employment law. We are very excited to have Trey join our team, and we're also excited to have him joining us here today. Trey?
Thank you, Justin. I'm glad to be aboard, and thank you all. We're excited about presenting to y'all today. So for those of our attendees who are licensed attorneys, we will be submitting CLE requests on your behalf, and we also send follow-up emails attaching the MCLE certificate for attorneys and HR professionals. Although we can't meet face-to-face today, we still want to answer as many questions as we can. If at any point during the presentation you have a question you'd like answered, please look at the bottom of your screen and try to click the Q&A button at the bottom. And we'll attempt to answer as many questions as we can at the end of the presentation. If we can't get to your question today due to time consideration, please feel free to reach out to us after the presentation over, and we'd be happy to discuss with you further. With that said, I'll turn it over to Justin to get us started. Justin?
Thank you, Trey. Like we talked about, we're here today to talk about how the pandemic has changed our operations, impacted our workforces, and what we need to do as HR leadership, as in-house counsel, to help our organizations not just survive this next transition period, but survive. And I think the important thing for us to remember as we go through this process is the extent to which the last year has been transformative for our operations and has impacted us. It's difficult sometimes to think of the pre-pandemic times and what our workforces look like back then, but we look at the changes that we've had during the last year. Within the last year, we had, for the first time in our country's entire history, a federal paid leave law mandating paid leave for certain groups of employees with certain companies with 500 or fewer employees. We look at the way that our workforces have changed. A majority of my clients told me pre-pandemic, even as early as early 2020, many of them were having difficulty fully staffing their operations. There was a shortage of skilled workers to be able to fill those positions we had available. We transitioned into the pandemic, obviously, and there were significant job losses as a result of the uncertainty that we were experiencing at that time. And now, as we're beginning to emerge into what is hopefully a post-pandemic workplace, what we're increasingly seeing is a combination of both of those situations. We have clients where there's a shortage of that skilled labor, shortage of people to fully staff. Other clients are still experiencing a demand shortage as a result of lockdowns and other government measures. And so we're kind of facing the worst and best of both worlds in that situation as we're coming out of that. But more importantly, what I want to talk about here today with you guys at the outset of the webinar, at least, is kind of a consideration of how the pandemic has changed where and how we're performing our work. I want to go back to pre-pandemic times and what did that look like specifically in terms of where we were working and how we were working. Many of us, as we'll talk about here in a second, have increasingly gone to at least a partial work from home or a primarily or exclusively work from home posture as a result of the pandemic. Going back before March of 2020, but before any of us really knew what COVID was at that point in time, work from home was rare, but it was still increasingly common at that period of time. The Bureau of Labor Statistics studies have told us that in early 2021, about 5 million employees were working from home on at least a half-time or part-time basis. That represented just about 3% of the national workforce. Not a whole lot of people, obviously, right? But even that relatively small amount of number of people working from home on a part-time basis was still up almost about 175% versus just 5 years ago. By that same token, in early 2020, only about 7% of employers offered telework regularly to any component of its workforce, but that number was up significantly by about a factor of 5 over the years before that. And we had primarily seen the increasing availability of telework for a large scale and a large proportion of the workforce, driven by emerging technologies. Initially by Skype. As time went on, we had FaceTime, we had Zoom, we had Microsoft Teams, all these technologies coming around, increasingly making it available, although still relatively rare, to use telework in those types of environments. So what happens then? We get to whatever your chosen date for the pandemic was for you personally. How did it first begin to impact you, your family, your company? Sometime in earlier mid-March, I would imagine. And suddenly, many of us, are no longer seeing most of our coworkers face to face. We're all of a sudden part of the Zoomy bunch, right? We're staring at our coworkers on a screen. We're encountering how to manage our client relationships, our customers, let alone our employees, through remote interfaces, through remote contacts. And how did that impact our ability to do that, and how we interacted and how we interfaced with our employees? A lot of these statistics, these are national statistics. A lot of them can be individualized, obviously, and they're known to you all personally. Immediately after the pandemic, by May of 2020, over a third of all workers within the United States were working from home or remotely on at least a part-time basis. As shutdown orders have slacked or have been removed, as the pandemic has at least lessened in severity within different regions, within different states. Increasingly, we have seen that number scale back, right? Throughout June and into February of 2021, at this point, we're about 1 in 5 workers within the United States are working remotely on at least a part-time basis. That is down significantly from where we were at the beginning of the pandemic, but it's still important to remember where we were back in January of 2020. At this point in time, we still have 7 times more employees nationwide working from home on at least a part-time basis than we did pre-pandemic, which is a magnitude larger number of employees across industries, across positions, working within that environment. And from an HR professional perspective and from a legal perspective, raising those issues of how to manage employees that are out of our sight, with whom we don't have face-to-face contact on a regular basis. How do we manage that employment relationship? How do we enforce our employment policies, work rules, and all of those sorts of things? As we move forward, I think what we're going to see, the impact in the availability of telework is going to be driven by a few different considerations. One, obviously, is employer cost. A lot of companies have realized there are significant savings to be had by virtue of not having an employee in every office, at least. That's one. The next one, obviously, I think would be the severity of the pandemic. And if the pandemic continues to abate, which we all hope it will, that obviously gives increasing opportunities to employers to bring employees back safely without concerns of possible infection and exposure within the workplace. And more than that, we also have to look at what jobs lend themselves to telework. And the Bureau of Labor Statistics has given us a wealth of data on that point. And what they've told us is that about 44% of all positions within the United States have the ability to telework, even if the employee or the employer choose not to. And that the bulk of those positions, the bulk of that work is about what you would expect. Positions within the professional services, education, finance industries, and things like that. Whereas businesses that require more face-to-face contact, entertainment, retail, things of that nature, obviously there are fewer opportunities there. What we've seen, though, is that telework has become normalized across industries. Telework is no longer available or deemed appropriate generally for just IT professionals or just for individuals who touch base with many different clients. Across job types, across industries, telework has become normalized. And many employers, many companies have said that moving forward basis, they're not planning to bring employees back whole scale immediately. Google and Apple have said that it will be at least summer of 2021, but before they bring employees back into the workplace. Spotify has said that they don't know that they'll ever do that. And so it depends upon the company, but increasingly we're saying that the work from home, which was a temporary solution throughout the pandemic, may not be temporary. It may be permanent on a broad scale or on an individualized basis. And so our question for y'all is, how do we manage that as we're returning to in-office work, as we're returning to work where we're bringing employees back? How do we decide when we have to allow work from home on a permanent or temporary basis? And then how do we look at those employees where we have cost savings or there are certain benefits to working from home and we want to make those allowances for employees? How do we make those discretionary decisions to allow it even when it's not required, to allow that to our employees without also running afoul of the applicable laws? These are the big issues that we're going to walk through here in about the first third of the webinar here today, is those issues that pertain to the availability of telework, how it impacts your operations, when you have to provide it, and when you choose to provide it. And this broadly speaks into two groups of issues. One pertains to disability accommodation in the assignment of telework and how we navigate those issues. The second would be navigating wage and hour issues, particularly as to non-exempt employees when they're working remote, they're working out of site, they're not working where they have a supervisor immediately to their right or left, enforcing working hours, enforcing work rules, and things of that nature. So let's start with a scenario, right? Let's walk through a scenario that I'm sure that most of you who are in HR leadership, who have employees working remotely, have probably seen already. Let's say you have Joe. Joe works in a sales position, approximately half of which requires face-to-face contact, half of which can be done at home. Joe's diabetic, and throughout the pandemic, we kind of split his job up. And we said, because you're at high risk, we're going to allow you to work from home only. You don't have to come in and do face-to-face work. Joe's coworkers have been picking up some of that slack throughout the last year, and Joe's been doing that work at home on that basis, handling just the paperwork. As the pandemic is hopefully ending, Joe comes to you and says, since I've been working at home for the last year, I want to keep doing that. I want to keep the light duty job that I've been doing without having to come in and work face to face. Some of the pertinent questions we need to ask ourselves is, first, is Joe entitled to a reasonable accommodation for his diabetes? Second, is permanently working from home a quote unquote reasonable accommodation for Joe's position under the ADA? Third, does fear of contracting COVID-19 entitle Joe to a reasonable accommodation on the basis of his diabetes and the fact that he's high risk as a result of that? And what other considerations pop up in terms of how we might manage Joe's position? The first question, is Joe entitled to a reasonable accommodation for his diabetes? Of course. Diabetes is a per se disability under the ADA. If there's a restriction that prevents him from doing certain components of his job or limits his ability to perform the job as assigned, we have a duty to go through that interactive process to identify whether a reasonable accommodation is available for diabetes. That's an easy answer. The much more complicated question, I think, is remote work in this context a reasonable accommodation for Joe's condition, for Joe's diabetes? The law tells us that we don't have to create light duty positions as reasonable accommodations. If it involves removing an essential job function, then that is a per se unreasonable request and doesn't have to be granted by the employer. In this case, if Joe's job requires half the work be done face to face, then that would seem to fall into the camp of being an unreasonable request from Joe, and one that we wouldn't have to grant. The issue we're probably going to run into, and the argument that we would get from employees, is, well, I've been doing this for the last half year or the last year or so. I haven't been doing the full job. Did we tacitly create a new position throughout that time period? That's a difficult navigation or argument to navigate, but I would take the position that this was a temporary assignment form, that this was a temporary allowance for Joe at his request because it was high duty, high risk, but we never got away from that. But that's definitely an argument that we're going to have to anticipate encountering for those employees for whom it's been allotted. If we don't allow work from home on a permanent basis because it's removing an essential function or otherwise, what do we have to look at? Does that end our analysis? At that point, can we tell Joe, no, Joe, you don't get to work from home, so we're going to deny your request? The law and the EEOC guidance tells us that's not the case. We have a duty as part of that interactive process to look at not just Joe's request, but to consider whether there are other accommodations that would meet Joe's needs. And in this case, a lot of it would pertain to looking at alternative accommodations. Are there positions that Joe is qualified for that are vacant within our position or within our organization that we're not going to create, that we can assign Joe into, that would accommodate his need to work from home? That's potentially one. Are there enhanced safety protocols? Can we put Joe into a position that he's qualified for and that is vacant that would allow us to provide him with more social distancing to protect his high risk status? Can we enforce the use of PPE to protect Joe? All of those are potentially things that would get to Joe's high risk status and protect him from that perspective. But at the end of the day, we want to look at this and we want to remember that we need to use the ADA's interactive process to manage those requests from employees who seek to work from home, seek to work remotely on either a permanent or temporary basis to manage their high risk status, to manage the potential implications were they to contract COVID, and to not be kind of approaching that on a wholesale basis. Each of these analysis and each of these decisions need to be made on a case by case basis. And we potentially run afoul and run into technical violations of the ADA if we start grouping them together and saying, Joe's request is just like Jane's request last week. So we're going to deny it as well. And we don't perform that individualized analysis as to Joe. So let's take Joe off the table, right? Joe's situation is, I think I'm entitled to a reasonable accommodation under the law. You have a duty to allow me to work from home on a permanent or temporary or part-time basis. That's one situation. A lot of employers are going to run into a completely different situation. And this is probably more likely to be the more common situation, which is the question is not, do we have a duty to allow work from home? But we choose to do so as a company, or an employee requests this because they like the flexibility of working from home. How do we go about managing those issues for those employees where we don't have to do this, but we think there are cost savings, or we think it's a perk for our employees to allow them sometimes or permanently to work from home? Obviously, employers have discretion to allow telework, to allow this sort of situation. There are certain wage considerations that we run into. If an employee is requesting working from home, and that's a light duty role, or that's tantamount to a transfer to a less specialized or onerous position, companies can make allowances. We can make wage modifications in those kinds of situations if this is actually a transfer to a new role. Obviously, if we have considerations related to a request for accommodation, we need to make sure we're not stumbling into retaliation claims here, where the claim can be made that we're modifying a salary, not because it's a new role, but instead because they requested accommodation and that this is somehow punitive as to that employee. But we've got discretion to do that. The flip side of it is, as we implement these discretionary decisions, we potentially run into allegations and claims that there's more favorable treatment of some employees. And so we, as an organization, need to make sure that as we're making these decisions in terms of defining what positions cannot work from home, how often they get to work from home, whether this is at the employee's discretion or whether there's some type of a rotational work schedule, however we are setting up those work schedules, we need make sure that we're not giving innuendo to discretionary or more preferable treatment of some groups of employees. And I would strongly recommend that as we're making that decisions, we look within job classification types, within work groups, and that we've got some type of defensible position to be able to look at this and focusing on why an employee or a group of employees are being allowed to do so, why some are not, and be able to defend that with some type of legitimate criteria, some legitimate business reasons underlying why those work from home decisions are being allowed. I want to transition a little bit at this point, get away from the telework as disability accommodation or the discretionary features of it, and get into how do we manage from a wage and hour perspective those employees that are working from home. The classic example is we have an employee who's non-exempt. He works from home 40 hours a week. He's supposed to work from 8 to 5. Yet every time somebody calls Joe, Joe never answers his phone. When we send Joe an email, it takes 3 or 4 hours to respond. When somebody does get Joe at home, it sure as heck sounds like The Price is Right is on in the background, and Joe's really just not actively paying attention and actively working. The questions that pop up there: can we monitor Joe's productivity? Of course we can, right? How do we do that lawfully? If you've got a good employee handbook, if you've got the right privacy discussions, the right privacy caveats in our employee handbook, we have a right to monitor our employees' computer usage or the time our employees are logged on. That's a consideration that's available to us. The key there is enforcing that consistently, not doing that from some perspective that would again lend itself to a suggestion that it's not productivity concerns that are giving rise to policing Joe's working time, but instead Joe made a complaint last week that his pay card was inaccurate, or Joe complained last week that he hadn't gotten a promotion, and that's why we're paying attention to him. That's going through that process deliberately, being able to defend the business and productivity reasons, having a paper trail, having a progressive coaching and discipline process that walks through those criteria gives us a much more defensible basis to be able to explain why we've made those decisions. Can the company require Joe to work specific hours during the day rather than set number of hours per day? Absolutely. We do that we do that within an office all the time. Uh, that is a core function of working in an office in many situations. We can absolutely require Joe from work to 8 to 5 rather than just working 8 hours a day at his consideration or at his availability. The key is going to be enforcing that as to Joe and training our supervisors and managers to enforce those wage and hour processes and policies as we go through that. The key to keep in mind here, I think, is that we've got the flexibility to set work rules even when employees are working in a remote environment. Um, the work from home feature that gives employees a benefit to be able to work in that posture, but in no way does that exempt or immune them from the expectations that we might have from employees who are otherwise working within the office. We can set specific limits on hours. We can set specific hours to be worked, and we can require availability, and we can enforce those rules as to those employees. I think the way that we run into issues here is a fewfold. One is if there's inconsistent or disparate enforcement there. And from an HR perspective, that really falls back on HR leadership and how we go about managing and training our supervisors and our managers who have the difficult job of enforcing these rules and enforcing these policies as to employees that they don't have line of sight visibility as to, those employees that they can't see necessarily. The flip side of it also is going to be not just how do we make sure that Joe and Joe's coworkers have the ability or are working when they're supposed to, but what do we do in the situation where we've got an employee who's working remotely? We may not have seen this employee for over a year at this time. And when that employee turns in his or her pay card, we look at it and it says, wait a second, this is a full-time job with sometimes overtimes available. But now this employee is reporting that they worked 60 hours in the last week, and there are no apparent work reasons or demand reasons or anything like that that necessitated 20 hours of overtime. How do you manage that from a wage and hour perspective? Again, the FLSA tells us if we have to pay employees for hours worked. Unless we can prove that this is fraudulent, if we can, conclusively prove that, which is very difficult, then we need to pay the employee for the hours that they're reporting. Does that mean that employees in that type of environment are able to report any hours they want to, and the employee has no remedy for what appears to be an abusive situation? Of course not. And at that point, we kind of fall back on some of our standard employment policies, which so many times is if you're going to be working overtime, get prior approval from your management, get prior written approval, get email authorization. If we run into situations like that where it appears to be that someone's taking advantage of those allowances, then we really need to make sure that we're proactive from the beginning across employees, across job types, and enforcing those policies as we increasingly and for a longer period of time can't lay eyes on them and don't know exactly when they're logged into their workstation or when there are those sorts of issues. I'm almost done with my part of the webinar before I turn it over to Trey. The last part that I wanted to address was what I think is the elephant in the room at this point, which is COVID-19 testing and vaccination policies for employers. I know a lot of our clients reached out to us back after Pfizer and Moderna both released their phase 3 results, and it looked like we were finally going to get a good vaccine for this back in November and December. And at that time, we went through some preliminary discussions about what mandatory vaccination policies might look like, but it seemed really premature. What good is a mandatory vaccination policy unless we can mandate vaccines, unless there's sufficient supply? Very thankfully, it appears that we are not too far away from being in a position where there may be large scale supplies largely available to big groups of employees and people more generally. So I wanted to talk through what are our obligations from an employment perspective if we choose to mandate these mandatory testing and vaccination policies, and what are some of the considerations that you want to keep in mind as you decide whether those are policies that your organization wants to implement. The big question: can employers require employees to submit to COVID testing on a regular basis? And can employers mandate employees provide proof of vaccination as a condition of continued employment? The answer, generally speaking, is yes. Yes, you can. And we'll walk through kind of the hows and whats of it here. But the EEOC, back at the beginning of the pandemic, deemed COVID-19 to be a direct threat to workplace safety. Because it was a direct threat, it meant that employers could implement regular COVID testing and exclude from the workplace those employees who tested positive until they were recovered. From a vaccination perspective, we can require vaccination so long as doing so is consistent with our business necessity. And the two major caveats that we'll discuss here in a second allows for the reasonable accommodation of employees' sincerely held religious beliefs and employees' disabilities where they're applicable. The first big caveat to that, the caveat to yes, we can require employees provide proof of vaccination as a condition of their employment, is in disability accommodation. And the EEOC's guidance and the EEOC's regulations under the ADA tell us that we can exclude employees from the workplace due to the effects of a qualifying disability if they constitute a direct threat. And the direct threat analysis basically look to their own safety or the safety of someone else. And the direct threat analysis looks at what is the likelihood of harm, what is the severity of harm, what's the imminence of harm, basically going through kind of a thoughtful process in terms of looking at what that harm would be. The EEOC said back in March, COVID-19 is a direct threat to employee health and safety. Because of that, we can require vaccination of employees so long as if we have employees who, for example, have autoimmune conditions or other disabilities that prevent them from taking the COVID-19 vaccination, we must have a process in place that allows for the consideration of possible reasonable accommodation for those disabled employees with regard to what is otherwise a mandatory vaccination policy as to them. And if we can identify a reasonable accommodation that would allow those employees to remain employed, we have to provide that accommodation unless it would impose an undue hardship. And under the ADA, the undue hardship analysis looks at would the employer have a significant risk of incurring a substantial cost in relationship to allowing that reasonable accommodation. Some of the accommodations we're going to look at, we got to go through that interactive process like we talked about previously to begin with. But some of the accommodations we look at go back to the beginning of the webinar here. Can the employee work from home? Is there the existing position? Can it be done fully from home with preserving all essential job functions? Is there another position the employee is qualified for that would allow them to work from home? And if that's the case, if the employee can indeed work from home, there's a good chance that we would be required to allow them to be exempt from the otherwise mandatory vaccination policy and to put them in a position where they need to be able to work from home. At the same time, it could also be we're going to mandate strict PPE adherence, mask wearing, face shields, things of that nature, even as the pandemic begins to wind down to protect that employee. There could be situations where we look at social distancing, other safety protocols and whatnot, but we have to go through that process using the employee's medical certification, using the employee's restrictions as a guide to determine whether there are modifications to his or her job or their workplace to determine whether or not we're able to accommodate around the effects of that disability. The bottom bullet point is important. Like we talked about before, reasonable accommodation never has to mean creating a light duty job where the employee is doing 75% of their essential functions, but not the full job. So keep that in mind. And the other thing to keep in mind is this all has to be on a case-by-case basis, meaning that we look at the individual employee's restrictions as well as what the circumstances are at that point in time. And case in point might be, right now we are still in the thick of the pandemic. San Antonio is still reporting about 180 cases per day. If we get later in the summer where COVID is not as prevalent, where there's not as much at least of a risk within the workplace, those considerations may also come into play in determining what is a reasonable or what is an unreasonable accommodation in terms of allowing exceptions to that otherwise mandatory vaccination policy. So we have to consider that there are variables on each side of this calculation that we need to consider as we're going through that accommodation process. And then finally, the last point of accommodation that we may be likely to run into from a mandatory vaccination policy is that of religious accommodation, which most employers run into much less frequently than requests for reasonable accommodation under the ADA. Title VII requires us to accommodate the sincerely held religious beliefs of our employees, potentially including employees who have a religious objection to taking vaccines, including the COVID-19 vaccine. If you get a request for that type of accommodation, the first point to keep in mind is religion is construed broadly under Title VII. If we are left in a position of denying a request for accommodation and the basis for our request is we don't think this is a sincerely held religious belief because we've just never heard of it before, we're really risking significant liability there. If instead, the reason we're denying it is the employee's taken vaccines every other year for the last 10 years, and there's no demonstrable change in his or her quote unquote beliefs there. That's potentially another situation, but I really recommend that to the extent we can, we're not admitting or granting or denying a religious accommodation request unless we've got a lock solid reason there. And that should be a very deliberate decision that we go through internally. Instead, we look at, can we accommodate this request without undue hardship to the company? Under the religious accommodation exception, undue hardship is defined as something that's more than a de minimis cost. So if the accommodation would impose a more than de minimis cost on your organization, we don't have to grant it. It would be undue in that situation. But some of the accommodations we're going to look at are the same as under the disability accommodation: working from home, enhanced PPE, workplace modifications, things like that. But be aware that both of these accommodations need to be allowed for under an otherwise mandatory policy as we go through it. And my last point before I turn you guys over to Trey would be, I think everybody on this webinar is going to understand this. I think you guys are going to understand what the organization's duties are and what your responsibilities are from an HR and legal perspective. Train your supervisors, train your managers to know what to look for, because employees are not going to use magic words when they're making these kinds of requests, and we don't want to have those kinds of requests fall through the gaps. So with that said, really appreciate everyone being here today, and I'm going to turn it over to Trey to take you guys home.
All right, thank you, Justin. If I could see the next slide. Now, the guidance related to COVID-19 has been confusing and at times conflicting. So when it comes to social distancing, I'm proposing the guidance of the one alligator rule. And the one alligator rule suggests that anytime you're supposed to socially distance, you should keep one alligator between you and the person near you. Now you may say, Trey, that provides absolutely no additional guidance. Alligators are all sorts of lengths and sizes, to which I would respond to you, if anytime you're near an alligator, particularly the business end of one, you're going to want to keep at least 6 feet distance for safety purposes. Next. Now, the CDC has provided updated guidance as of March 9th related to what fully vaccinated persons in the workplace should do, and March 12th as it relates to quarantining. Now, their most recent guidance is that persons who are all fully vaccinated can have in-person meetings without socially distancing, without masks. Fully vaccinated under their definition means that they are 2 weeks after the final shot has been administered. Now, by the final shot, I mean either 2 weeks after the one round with Johnson & Johnson, or either 2 weeks after the second shot administered with Pfizer or Moderna. Now, this should be consulted with OSHA's guideline before going mask-free. OSHA was supposed to release emergency temporary standards as of Monday, but they are behind and they've indicated as such. Their last guidance has suggested that employees, whether vaccinated or not, should be treated as if they are non-vaccinated and that there should continue to be masks in the workplace. OSHA's last guidance in January suggests that they believe that COVID-19 vaccines do not show evidence of preventing the transmission of the virus person to person. Now, when you are going to have an in-person meeting that is maskless and people are fully vaccinated, they need to sign some type of acknowledgement, and they need to understand that acknowledgement, if they make a misrepresentation on, is subject to termination for putting you at risk, other employees at risk, and your customer base at risk of infection. Now, if you mandate attendance at an in-person mask-free meeting, you need to consider some of the issues Justin brought up about, because they're essentially mandating that they be vaccinated at this point. I would discuss with council prior to doing so, and always make sure to give your employees appropriate notice. Next. Now, as it relates to quarantining, the CDC has recommended that you follow local health guidelines. And San Antonio has indicated that if you have been within 6 feet of someone with COVID-19 for 15 minutes or more, you should quarantine for 14 days. However, quarantines may end early under CDC guidance if you are asymptomatic and after 10 days, even whether you have a test or not, or after 7 days, if you have a negative COVID-19 test. Now, the testing must have occurred at least 5 days after the quarantine. Now, your employees that have quarantined should continue to watch for symptoms 14 days after exposure. And if they're symptomatic, they need to immediately self-isolate and contact local public health authorities. Or a healthcare provider. Metro Health in San Antonio area will actually contact people and give them instructions whenever they have tested positive here locally. But in any event, if someone has been potentially exposed, they need to continue to wear a mask, stay at least 6 feet, wash their hands, and we should all be avoiding crowds. Next. Now, quarantining, if exposed under OSHA's guideline, is similar to that of San Antonio's in the sense that if you've been within 6 feet of a COVID-19 positive person for 15 minutes or more in a 24-hour period, you need to quarantine. Now, close contact, this is guidance from the CDC, but it is not clear whether or not that includes having a mask or not. It is assumed that this includes mask or maskless contact because the CDC believes the general public has not received training or proper selection for the use of respiratory PPE, and therefore determines that they, irrespective of if they have a mask or not, you should consider 15 minutes with them to be an exposure. Now, that 15 minutes has not been clarified if it's consecutive within the 24 hours or if it's 5 sessions of 3 minutes each or 30-second sessions. So we need to be very careful in when learning of when the exposure is, who spent what time with them. And of course, quarantine is also suggested for anyone that has physical contact with others that are positive for COVID, sharing eating or drinking utensils, or if they provide care for someone at home that has COVID-19. Someone who has sneezed, coughed, or allowed respiratory droplets to get on from them should also quarantine. And again, the CDC will continue to update its guidance, which it's been doing at least once a week. Next. Now, as we are aware, Governor Abbott has issued Executive Order GA34 that removes a mask mandate. It allows employers to open facilities at 100% capacity. It allows employers to continue to require masks of both customers and employers. In response to this executive order's announcement, Bexar County's Judge Nelson Wolf also issued an executive order indicating that if employers have health and safety policies that are not being complied with by customers, they can order them to be removed by officials for trespassing. Now, regardless of what decisions you make, you have the option to implement additional safety protocols based on your business judgment, whether that be temperature screening or voluntary occupancy limitations. But the local governments of Texas can no longer impose penalties for not wearing a mask or imposing more restrictive orders. The only exception to that currently is in high trauma service areas, and that is where COVID-19 infections are more than 15% in the hospital. Employers are also encouraged by Governor Abbott's order to look at the HHS's protocols. So the Texas Department of Health and Human Service has a checklist which pertains to training employees for appropriate hygiene, cleaning, and respiratory etiquette, screening employees and contractors for symptoms, prohibiting symptomatic or known exposures from returning work until they can prove that they're asymptomatic or have tested, redesigning the workplace or for social distancing or creating barriers, and also visible signage for people. They also have suggested employers with more than 10 people present consider one person dedicated to ensure health protocols have been adopted. Now, with all these restrictions, sometimes it's just best to not come in contact at all. Next. Now, although it's not normal to use Spock's intro, their way right now are not fully returned to normal. Next. And as a result, we should not eliminate prior precautions, but we should update all existing policies and provide notices to our employees. Continue to look to OSHA, CDC, and HHS for guidance, and continue to encourage and require face masks. Now, just because a mask lift has been, or the lift of the masks has occurred, doesn't mean that you have no liability for COVID-19 contractions. Consider not only safety, but the morale of your employees that are concerned about COVID, attendance issues for those that may be exposed, and of course, your overall business operations that I know is important as we try to get back to the normal times. Next. Next. Now, there are no OSHA standards specific to COVID-19 listed in the statute. However, the general duty clause for implementing precautions still applies to employers. And as you're aware, that general duty clause indicates that employers shall furnish each employee a place of employment free from recognized hazards that cause or are likely to cause death or serious physical harm, and of course, to comply with OSHA's rules. I've listed some of the fines that are current for different violations. I note that for failure to abate and failure to post, those are actually daily fines. And then the willful and repeat violations are potentially $136,532 in their total penalty amount, which is for voluntary committing an intentional disregard or plain indifference that causes injury or that's reported. Next. Now, OSHA has proposed, as of January 29th, 2001, guidance to mitigate and prevent the spread of COVID-19. What they have indicated is that they propose a hierarchy of control from most important to least important to help prevent exposure to COVID-19. And their most effective or to least effective includes elimination or substitution and plans and prevention to either remove or replace the hazard of COVID-19. So what they propose is that employers should implement responsive preventative controls and have written COVID-19 prevention plans. OSHA also, again, emphasizes do not distinguish between vaccinated and unvaccinated employees, and make sure that both your employees and your management have clear training on what they're expected to do to lower their transmission or if they believe they've been exposed. Communication systems are key to be set up about COVID-19 and what is expected. There's also the fact that they want enhanced protocol for prevention and isolation. That means sending home people when they're sick or when they've potentially exposed, and protecting high-risk workers. Now, a lower on their level of efficiency, they believe, is engineering controls and administrative controls to help isolate people from the hazards and change the way people work. This includes reasonable modifications to work schedules, remote work where possible, staggering work schedules where people are working different shifts so that they're in less densely populated shifts, better ventilation in areas, and even alternative facilities, contactless interactions when possible, clearly marked signage, and installation of barriers whenever it's possible. And at the bottom of their effective level, they've listed PPE for their workers. So not only should workers be encouraged for their cleaning, the frequency of cleaning and disinfection when necessary, but encouraged to properly use their mask, train on how to use masks and how to maintain them. Next. Now, OSHA's retaliation standard prohibits discharging or discrimination against employees whenever they report infectious diseases, exposure, or unsafe work conditions. Also for reporting work-related illness. So if an employee believes they've been exposed to COVID, if there's some risk and they bring a report to you, it is essential to respond timely and in a constructive manner. Ensure the employee status change, if any, are for legitimate non-retaliatory reasons, and consistently impose equivalent discipline for work rule violations, whether they've made a report or not. So you should document, and this is going to be a mantra, but you should have a policy in place. You should document. You should have consistency in the application of your rules. If you had someone break a work rule last week and they didn't mention anything about COVID violations, and someone else broke it this week and they did, and you don't discipline one and discipline the other, you can potentially create risks for yourself for retaliation. Next. So what happens when an employee refuses to work and believes that there's an imminent danger? Right now, it's not really clear if COVID-19 meets a standard for an imminent danger under what OSHA believes to allow an employee to refuse to work, because no employer can really completely limit COVID-19 risks. But employees do have a right to refuse to work, but it must be based on certain elements. And that includes a genuine belief in imminent danger existing. Okay, there has to be a specific fear based on a specific fact. They just can't have a generalized fear of COVID. And it has to be one where reasonable persons would agree that there's a real danger of death or serious injury. And that employee has asked their employer to eliminate this risk, and it has not done it so yet. And finally, it has to be where there's no time to correct this through traditional methods of OSHA or otherwise. Now, absent an exception or request for accommodation, generally employees cannot refuse to return to work, but employers must take appropriate precautions to ensure the employee's safety. Next. So what do you do if someone refuses to go to work? They say, hey, I have a fear of COVID. Well, you should promptly, again, the mantra, document, and then you should promptly respond to them. And you should assess the level of risk for employees based on OSHA's exposure chart. Now, they have an exposure chart where they list serious, very high, high, medium, and low. Very high is going to be actual persons that are working with known exposure in labs or medical facilities. High exposure are in labs or medical facilities where it's possible they're exposed. And then medium exposure will be those in retail, those in high density populations, schools that have a lot of close contact with the general public. And then a low exposure will be when there's not much risk for interacting with the general public. And then follow the hierarchy of controls that we mentioned earlier. We've got to make sure that when you're reviewing it, assess the appropriate controls. Can you stagger this employee's shift? Can you limit their customer access? Can you create some type of encouragement for them to use PPE? And you can do that by training them. You can do that by reminding them of what proper usage of the mask is, proper hygiene and workplace sanitation. But simply put, it is imperative that employers demonstrate a good faith effort to reduce or eliminate COVID-19 hazards in the workplace. Contemporaneous documentation and implementation of these efforts is key to demonstrating why it is unreasonable for an employee to just refuse to come to work, and also uniform application of your policies. Next. Now, the Texas Workforce Commission has identified that there are certain persons that are eligible for unemployment benefits should they refuse suitable work. And it's a case-by-case analysis, but it generally speaking will only be provided after analysis to those who are 65 years or older and or have certain medical issues like a heart condition, cancer or diabetes, or a weakened immune system, or if they're in a household with someone that's at high risk. Also, if someone has been diagnosed with COVID-19 or lives with a family member in their household that's been diagnosed with COVID-19, and by diagnosed, I mean by a source authorized by the state of Texas, and they have not yet recovered from that diagnosis. Also, anyone that is currently quarantined from their COVID-19 or who is self-employed can apply for the unemployment benefits. Next. Now you have your employees in the workplace. They've agreed to apply to your rules as it applies to most things, but maybe they haven't. Maybe you have employees that are refusing to mask up or socially distance. Maybe you've mandated vaccines, or you might have issues with customers. Next. What should be done is, again, implement documentation and a plan. Provide notice of your COVID-19 plan to your employees. And renewed internal communications. There has to be a campaign of notices to employees prior to the return of work. Make sure that you have these well-documented notices, what their expectations are, and remind both managers and employees of mandatory compliance and the consequences. Non-compliant employees can be disciplined and should understand the levels of discipline up to termination for not complying with the company policy. Just because COVID-19 has changed the way we do things doesn't mean that you as the employer cannot still enforce the rules. There's certain rules as they relate to general practice, not having your cell phone at work. And then there's those at safety. You're not allowed to drink on the job. You're not allowed to, drive to and from sites while on your phone. This is a safety rule, and make sure that they understand that their non-compliance, how it will be handled, and that your management knows how that should be handled. And again, uniformity in enforcement of these policies. Next. Now, every time an administration comes on board, whether it be this administration, the prior one, Obama's, Bush's, or Clinton's, they will have new agendas that they want to move forward. They will have new personnel, and they will have new ideas, or they'll have programs they're pushing forward. And Biden's administration is no different. First off, starting with the Department of Labor. Next. The Department of Labor has recently issued an opinion letter about compensable travel. Justin has already talked a little bit about, what we do when our employees are teleworking or the remote and how we handle that. But there's also now additional guidance for what's compensable when we're traveling to and from work by our teleworking employees. Now, when travel is part of an employee's principal activities, it can be compensable. Okay, the rule is not that it is necessarily, but it can be, let's say, for instance, between work sites. But travel time in your regular commute or between office and home in your regular area is not compensable. And it's not compensable, particularly when an employee chooses to perform some work before going to the office or chooses to perform work at home after leaving the office. And they've had sufficient time between their telework and their office periods to use for their own purposes. And I think this is best demonstrated by an example. Next. Okay, Jane has a doctor's appointment. She has it from 8:30 to 9:15. She's already asked her work, and they've already cleared her to work at home a little bit before her appointment. So from 5 to 6, she does some work at home, and then she performs a little bit of personal activity from 6 to 8 in the morning. She goes to her appointment at 8. She finishes 8:15 and arrives sitting at her desk at 9:30. At the end of the day, she commutes home, and from her office, as usual, performs no work during the commute or after she arrives. Next. So, is Jane's 1 hour of travel time from home to the appointment and the appointment to the office compensable? And my second question, is Jane's commute time from her office to home, where she began work that day, compensable? The answer, according to the Department of Labor, is no, it's not compensable. Again, when an employee chooses to perform some work before traveling to the office or chooses to perform work at home after leaving the office, and in either case has sufficient time in between telework and office work time for their own purposes, that time they spend traveling between home and office is not compensable. Next. Next. Now, Biden's administration, they have been quick to issue several executive orders, and some of these executive orders, of course, have provided what is to come or what we are trying to anticipate what they will mean for employers. Now, one of those is the executive order on protecting workers' health and safety. In this particular executive order, it directs the expansion of OSHA's COVID-19 enforcement, which was supposed to include this Monday, March 15th, an announcement on a temporary emergency standard that we've already discussed. That has not yet been launched, so we're not quite sure where they stand on their guidance, besides what they issued at the end of January. However, the Department of Labor's Office of Inspector General has been very critical openly to OSHA, and they're saying that there's been 15% increase in complaints at some work sites between February and October of last year, but 50% less inspections were conducted. Also, apparently OSHA has not been properly documenting remote inspections, and it's hard to delineate between ones that were on site and that were remote. So we should all expect increased inspections and enforcement and some type of guidance from OSHA that is updated on masks and use of masks in the workplace here shortly. Now, there's also been an executive order on advancing racial equity in underserved communities. This is intended to eliminate barriers to federal services and federal contracts. It also expands demographic data collection. So for all employers that have federal contracts, federal services, including private employers, there may be an increase in demographic data, whether it be related to ethnicity, gender, disability, income, veteran status, et cetera, that will be shared with governmental entities. And lastly on the list is the executive order on gender identity or sexual orientation. Now, this applies Supreme Court's recent Bostock decision that prohibits sexual orientation or gender identity discrimination in federal agencies or with those that have federal contracts. And this will apply to the private employers that have those. Next. Now, the COVID-19 relief bill, the employers now have discretion between April 1st of this year and September 30th of this year to offer paid leave or to not offer paid leave under the Emergency Paid Sick Leave Act and the Emergency FMLA. Now, this is an increase of 10 days of leave that, again, is entirely discretionary. However, as under the Family First Corona Rights Act, a payroll tax credit is provided for employers providing leave. There is also a new non-discrimination rule that applies. Employers may not discriminate in offering leave in favor of highly compensated, full-time, or based on an employee's tenure. Now, the EFMLA leave available for employees is for quarantining or for caring for someone that's quarantining. And then the EPSLA leave is available to obtain vaccines or recover from vaccine-related conditions, illnesses, or disabilities. Importantly, if the employer has asked someone to get the results of a diagnostic test or they're waiting on it, and that employer has also agreed to provide this discretionary leave, that will also apply. Next. Lastly, on my topic, the House has recently passed the Protecting the Rights to Organize Act of 2021. Now, it represents the most extensive reform of federal labor laws in decades to be proposed, and it has potential consequences for unionized and non-unionized employers. Now, there's no real telling what it will look like once it gets through to the Senate, or what will get through to the Senate, or how it will. But right now, as proposed, it proposes prohibiting mandatory arbitration agreements, codifying the ABC tests for independent contractors under the NLRA, expanding NLRA penalties, and also redefining joint employer, and also the term supervisor to frontline employees. So this is something that we don't know exactly what it'll end up looking like, but I would propose that everyone keep their eyes on and be aware of, because it is currently in the pipeline. Next. Now, you may be wondering where to find updates. I would propose to continue to check the CDC website, as it should be updated at least on a weekly basis. The EEOC will continue to have guidance. OSHA, the Department of Labor, and the Texas Workforce Commission are also great sources to try to check and see what's going on, what the new guidance is. And of course, you can also always contact us. I'm also very happy to announce that we will be launching a weekly podcast to cover updates on the law, issues in the workplace, and different laws and cases and how they impact different industries. We will send out more information about the podcast, its official launch date, and how to get information regarding it, but we are very excited about that. Next. And now, I'm going to turn things over to Justin, and we're going to both kind of review and see if there's any time for some Q&As that were submitted.
Thank you, Trey. I don't see any questions in the Q&A box here. Obviously, we've got the chat available as well. If anybody did have any questions pertaining to the presentation today, we've got a couple minutes left here. We'd love to make as much use of y'all's time as we can. We'll keep our eyes open for that. Otherwise, I do want to say, like I said at the beginning, we have greatly missed being able to meet with everybody face to face. I know all of us here hope that for myriad reasons, things continue to improve, that we're able to all get together, have a delicious breakfast, one of our breakfast briefings at some point in the not too distant future, at least. But we appreciate you making a little bit of time for us today, obviously, to provide updates. If anyone has any questions that we don't want to phrase today, or you don't want to raise today in front of a group, we're happy to address them to one of our many attorneys afterwards. And I just saw one coming through here right now, and I apologize. I'm reading as I'm talking out loud, which is always a fraught situation. The question was for qualifying reasons for caring for an individual subject to a quarantine or caring for a child whose school is closed, are these still paid at the employee's two-third rate? And my understanding of the question, at least, is for those employees who are, for those employers who opt to continue to allow discretionary leave for employees who still have that paid leave available under Congress's extension of that act up through September of 2021, beyond April. Is that still capped at the two-third rate under the emergency FMLA rate if there are those qualifying reasons? My understanding, and Trey will jump in here and correct me if I'm wrong, but Trey, my understanding was that that is still subject to those same statutory caps, or at the very least, if an employer allowed for paid leave for those reasons, that the tax credit that came back at the very least would still be capped at the same levels that was initially set forth in the FFCRA. So if the employer allowed for paid leave beyond that two-third level under the FMLA, then in that case, you wouldn't be able to recoup those through the tax credits. And I'll mute myself and then let you guys know if I'm wrong.
Yeah, so currently the 10-day bucket of days that is being proposed to be extended starting from April 1st to September 30th is discretionary only. You are not mandated to apply. I don't know if that also clarifies, because I agree with Justin's assessment that it's completely discretionary. You are not required to do so. And if you make that decision, that is what you can make. If you do make that decision, that's when you could potentially get the tax credit.
Awesome. Thanks, Trey. We had one other question come through that was, will the PowerPoint be made available to the attendees? I think so. If you guys could email, I think you should have received an email from Christy Metter, our Director of Marketing. If you guys can reach out to Christy, if you'd like a copy of the presentation, please do so. And I think that won't be an issue, obviously, for you guys who are attending. The last question, I think, was, I'm trying to understand the question here. I think it was, for those employees who've been vaccinated, can we require some kind of an indication from that employee to be able to indicate that they've been vaccinated to the employees around them? I think that's a complicated question. I think as we go through the process, kind of like we talked about here today, for most of our, we were able to require vaccination if we choose to do so, if we're making those allowances for disabled or religious employees who need an accommodation there. In terms of kind of requiring employees to indicate publicly to their coworkers whether they've been vaccinated, I'm a little more concerned about that. I think that may be trying to impose some type of disability-related inquiry, which could potentially run afoul of the ADA. So I think before we did anything like that, I would really want to make sure that we had a deliberate conversation internally in terms of what that requirement would look like and how we would go about enforcing it. So with that said, really appreciate you guys turning in. We're a couple minutes beyond 1 already. It's great seeing all of you guys virtually at the very least. And like I said, we look forward to seeing you all again as well. Trey, you want to say goodbye?
Thank you all. I really appreciate the opportunity to talk to y'all. I hope you all have a wonderful weekend. Thanks for being here.